Welcome to Heald Law Academy, the place where you can quickly learn how to maximise the value of your businesses and safeguard your commercial and personal interests. I'm joined by David Dees, and we're going to talk about one of the most important aspects that holds major value, your company brand name, and what scenarios exist that could make it impossible to protect. So David, at what stage in company development should brands be looking to protect their name?
I would suggest right at the very beginning.
Why is that? Tell us.
Well, these days, people often start with a website, don't they? Well, the name associated with the website is going to become part of their brand as the business develops. So the first thing they'll do is look around to make sure they can get all the domain names they want, whether it's a .com or .co.uk or .eu, whatever it is, they can use those domain names to start building their brand. So that's the first step. The second step is to look at the company's situation. You can go on Companies House very easily for free and check all the names, and you can see if the name that you want to use is available. So that's a very, very simple thing that you can do. And of course you can then form the company that you need that's got your name in it.
Can you also see if other companies have already used a name that may be similar to one you're thinking about?
Well, that can be more difficult, because of course a lot of businesses are quite local, and there may be somebody in Sheffield that's using the same name that you're using in, say, Milton Keynes. So it can be quite difficult. One thing you can do is go to the IPO website. That's the intellectual property organisation run by the government. They've got a fantastic website. You can go on there and check all the trademarks, and you can check whether the name you want to use has already been trademarked by somebody else. But there's quite a lot of complication about trademarks that I can explain.
So I've heard a lot of cases where people have tried to trademark a name, but it sounds even too similar to another trademark. Is that also problematic?
Yes, what you've got to do is avoid confusion. The starting point is to realise that you can't trademark simply descriptive words. You can't trademark window cleaner. You just can't, because it's an ordinary expression of English. So what you've got to do is think of something that's distinctive and unique. Kodak, of course, is the most famous example. It's a made-up word. They are able to trademark it. It's associated in the particular trademark category with cameras and film, and so that works really, really well. So what a lot of people do is come up with something a bit unusual.
Just make up a word.
Make up a word, which they then associate with their particular business activity. If, however, you don't want to do that, for example, you might just want to call it Heald Solicitors, because Heald is the name of the person. That's fine. What they then do is create a design or a logo. We've all seen logos. The design, or get-up as lawyers call it, can be trademarked. So that's another thing you should do. And you can do it right from the beginning. It's not very expensive. Fill in some forms, pay some fees, and if you've got a nice logo or design, send it to the IPO office and get it trademarked.
So there are two sections here. First of all, trademarking your brand name, and second of all, trademarking your logo to make sure that nobody else is using that.
That's correct.
And you mentioned that you can't use just generic words. So what about a company, for example, Apple? That's a generic word. How come they were allowed to use that?
Because they've got a very distinctive brand associated with it. We all know the logo. We probably know the logo better than the words itself. It's very distinctive. That's what's been trademarked.
So you can just choose sometimes like an abstract word rather than something descriptive, as long as it's not, like you said, window cleaner or something like that.
You can, but it's the design and the get-up that's absolutely critical in cases such as that.
So these really are working in harmony. You've got to have the logo and the brand name. And what sort of problems have you come across where people haven't taken these precautions?
Well, there's confusion, and potential loss, and it's very difficult to enforce. There is an ancient law in England called passing off that's actually quite difficult to explain. It's to do with people's reputation, so it's a reputation that you might have. You might be called Smith Builders, and you might have a reputation in a particular town. If somebody else in the same town decides that they're going to be a building company also called Smith, it's a pretty obvious example of passing off. The idea is that they are confusing themselves with you, so that customers think that they are you. That's passing off. They're trading on your reputation. And that's an old
This is the
common
key
law.
element here.
Yeah, that's a common law remedy that's available to everybody, but it's very rough and ready, and of course you might have to go to court, which is always expensive. It's much easier if you can trademark it.
And how do you go about that?
Well, as I said, you can apply to the IPO,
And it's that simple.
and it's that simple. As long as you've got your design, or if the wording for your business is distinctive, then away you go.
Say I want to make a business in a different town and I want to call it Smith Builders. Am I able to do so because it's in a different town, or that name's already been taken elsewhere so I can't at all?
You can, of course. Smith is your name and you can use it if you want. Even if it wasn't, you could still do it, providing there's no confusion in the marketplace. Now, it may be a bit absurd to do it in a neighbouring town, but certainly if there's some distance away, the reality is for most small businesses there's going to be no confusion. So there'll be no damage to the other business, there'll be no right of action. So it's fairly harmless. You might have a problem, of course, if one of the businesses actually expands beyond their usual locality. There could be confusion ultimately if they started to trade in both towns and maybe across the region and ultimately the whole country. They need to be doing something a little bit more proactive with their brand, their design and so on.
What happens then? So say I'm Smith Builders, I set up a brand name in a different town, and then all of a sudden I become the best building company in the world, and as a consequence of that I'm trading in the original Smith Builders town. What happens then?
Well, that's an interesting question, and it's a situation that I have come across in a completely different type of business. The reality is that if you've already been using it for some time, then you're entitled to carry on. I think that these may be apocryphal examples of Marks and Spencer's, but they illustrate the point. If you're trading as Marks and Spencer's haberdashery in a town, and you've been doing so for years, it doesn't make any difference if there's a famous supermarket. You're entitled to use what you had before.
Do you think a lot of people think that a trademark can just be sort of one per person, whereas you can actually have the same trademark just as long as it's not in the same locality?
Well, we mustn't mix up passing off and reputation with trademarks. You can only have one trademark. That's a registered right that you've applied for. It's registered. You can see it on paper and you can show it to people, and it's much easier to enforce because of that. And there's a register. You can always say to someone, you could have gone to the register and had a look.
Now, on the flip side of this, do you get people coming to you saying, look, someone else has copied my trademark?
It doesn't happen very often because most people know that would be a crazy thing to do. There's got to be an overlap, there's got to be the same industry, and there's got to be a copy of the mark. People would be crazy to do it because they're basically wasting their own resources. Why would you do that? People don't tend to do that.
So ultimately, it's about people trying to benefit from someone else's reputation.
Yes, that's what you want to avoid. But looking at the positive side of it, we want our customers to have businesses set up with all the right things in place from the beginning, whether it's their website, the company name, a trademark if they can get one. All those things, if they set them up properly at the beginning, then it'll avoid problems later on. That's what we would recommend.
Wonderful. Thank you so much, David. We hope you enjoyed today's discussion, and if any of the issues mentioned are affecting your business right now, then simply call David on the number below, and remember to subscribe to all of our videos, and we'll send you some news of seminars and other events where Heald Law Academy will be presenting. Bye for now.